There are primarily three types of cases that could be brought when there's an injury caused by a product. And one type is a manufacturing defect. And that means it's a situation where there was a problem with the actual manufacture, the making of the product itself. Something like a bolt was missing or was not screwed in properly. That the product itself was not made the way it was supposed to be. Number two, there can be a design defect with the product, meaning the product was built properly, built to specs, but the specs were bad. There is a problem with the design. The part was not made strong enough, even though it was built according to the specs, and that an alternative design would have been safer. That's a design defect type of case. The third type is an inadequate or a missing warning, that the manufacturer did not have enough warnings or instructions about the product as to how it would be used safely. And we would show that better warnings would have prevented the accident or called the attention to the consumer of the potential danger with the product. So depending on the situation, those are the three types of claims that may be able to be brought. It is very important whenever there's a product involved in a case that the product itself be preserved. You have to have the actual product involved, it was involved in the injury in order to bring the claim. And then experts will need to examine that product depending on which legal theory is being used. But that's an overview of the product liability world. If you've been injured by a defective product, please call our office. It's important to get started quickly because, again, the product has to be preserved or you may not have a case. Please call our office. We'd be happy to speak with you.
Call Marcus and Mac on the Hurt line right now.